700 plus patents, 2 decades of experience, one global mission to protect your $1 million ideas. Ever wondered what separates a napkin sketch from a $1 billion business? Or why some ideas get stolen while others get sealed with ironclad protection? Well, today's guest has been on both sides of the patent battlefield. First, as a US patent examiner, and now as the fierce advocate behind one of the most trusted patent law office in the country. From nanotech to international filings, he's the go to guy if you're serious about safeguarding your innovation. Welcome to another episode of our Founders Podcast. I'm your host, Ash, and this is a show where I interview proven founders and industry experts who share their stories, strategies, and insights to help you build, launch, and grow your business. In this episode, I talk to Austin, the patent attorney. Austin, welcome to the show.
Thanks for having me, Ash.
Great stuff. Do you have a favorite quote, something that inspires or motivates you would like to share with our audience?
Well, it's probably very relevant to what I do, and it's from Thomas Edison, and it is the genius is 1% inspiration and 99% perspiration.
Indeed. Indeed,
Yeah.
it is, isn't it? And as we were talking about you a little bit before that, it all starts with an idea, but what matters is how you not just protect it, but also implement it and evolve it, right? So tell us about your journey then. I want to learn more about you. I'm eager to learn more about the person. Can you take us back to your roots and share with our listeners about your upbringing, your childhood? How did your early experiences shape your journey and eventually led you to become an attorney in this space? And were there any key influences from your family or surroundings that played a significant role in shaping your, spirit towards becoming an attorney?
Yeah, I think I have one story that kind of sums up a lot of that. I grew up in the on the Gulf Coast of Mississippi, and trust me, it gets hot during the summer. I mean, it's a very warm place,
Mhm.
humid. And my dad had a fish tank, and this fish tank was salt water, and it caught the house on fire. And
Mm.
but for the dog screaming and yelling and all this other kind of stuff, the house would have burnt down. So needless to say, that summer I was in the attic with my dad wiring the smoke detector system. So because it was a very spread out house, so if something was happening in the one part of the house, you wouldn't hear it in the other. So we had to
Mm.
wire it all the way through. And I thought to myself, there has to be an easier way of doing this. And that thought stayed with me for a very, very long time. And then I ended up going to school for engineering, and my background was civil engineering. And then we had to do a thesis in order to graduate. So we
Mm.
had to write a paper, all the stuff. And I basically did mine on an invention I had, which is a wireless smoke detection system, which would basically act as a relay system. So me and my buddy got together, we put together 2 smoke detectors, the battery operated ones, but then also took those wireless doorbells when they first came out, hot wired that thing. So basically, when one would go off, it would send an audible alarm and a wireless signal to the next one. And the idea was that you would be able to space these throughout your home, and it would relay, and no kid would ever have to hang out in the attic in the summertime in Mississippi ever again. And right. So I actually beat Kitty to this, is my understanding. I could be wrong, but I went back and I looked, and I think their first patent application that they filed was well after my thesis project was presented and put, and actually published, or at least is in the library at the University of Virginia. And, but I didn't have any money. I didn't know what I was doing. And I fell into that trap that a lot of inventors fall into. It's like, hey, I have this great idea. I really believe in it, but I don't know what to do. And the
Mhm.
other problem is obviously funding. I was just a college student, didn't have, barely making ends meet, eating peanut butter and jelly sandwiches every day because I was broke. And
Mhm.
therefore I, was unable to follow that invention to its conclusion for my benefit, but obviously somehow it got to the market eventually.
God, that's pretty interesting. I mean, writing a thesis or dissertation on your own invention. Kudos to that, right? Not everybody does that, you know.
No, I had to convince some professors to let me do it. They were like, I don't know about this. You're supposed to. I'm like, no, this is great. We're civil engineering. Fire safety has to be something. And they're like, okay, sure.
Let's do it. Let's do it. Great stuff. Cool. So let's back to some founder space then. I mean, I was talking with my friends last weekend, and I was saying, "Oh, I'm having somebody on my show who is look after like patenting and everything," and say, "Oh, yeah, we thought about patenting our ideas. Also, most of my friends are into IT." And we couldn't do it because everything is there, like every single idea you could think of, developing an app or right swipe or slide to buy or anything you could even imagine in software is already there. How do I know if my idea is even patentable in the first place?
Yeah, so you kind of hit on two things. Like, when would you know that something is patentable? And the other one is in the IT space or the software space. In
Yeah.
the United States, software is basically, it's impossible to get a patent now because of a decision by the Supreme Court saying
Oh,
that, basically software is nothing but abstract ideas. And it just basically goes back to the point of, I kind of explained to people, say you had someone who was super, super duper smart and they could do it all in their head, what the software is doing to bring in input, and then spit out an output, that can't be patentable.
mm,
Now, with general, do you know if you have some kind of invention, whether it's in software or not? You just because you can't get a patent on software does not mean that you didn't invent something, in my opinion. It's just not patent eligible. So the question that I always is, did you solve a problem? And the chances are someone else had that problem and was unable to solve it. So when you're working in your business and you're doing, in your area and you hit a roadblock and, sometimes it takes people 5 seconds to figure out the solution, that still might be patentable. Obviously, if it takes a longer time and it's a real big problem, that's where you should investigate whether or not you have a patentable idea and whether or not you want to protect it.
got it. And we were having continuous discussion on the similar topic, and there was a point where we started discussing like, okay, Amazon is an e-commerce store, right? That doesn't mean that we cannot create another e-commerce store because it's not something they invented. It's sort of like evolve during the internet era, right?
Right.
So basically, if McDonald's is in your city, that doesn't mean you cannot open a burger shop, because the more burger shop, the better it's served to the population, right?
Yes.
Could you break down to our listeners um, what is the difference between provisional and non-provisional patents? Like, I'm a 5-year-old or something like that. Very,
Yeah.
because we
Well,
don't understand it.
Well, the reason why they came up with the provisional patent, it was literally just a stopgap in the law. Everyone thinks that Congress came out and was like, "Oh, they gave us this tool, and it's a way to have a cheap patent." It's not. So
Mm,
basically, this situation arose where foreign filing. So the way it used to be was, if you file in your home country, you have a year to file in a foreign country under the Paris Convention. And therefore, but you would get the benefit of the earlier filing date in your home country. So say it was 20 years, you would have 21 years of coverage if you were a foreigner filing into the United States, because you had that extra year. Then you got your 20 when you filed here in the US. So in order just to fix that, Congress just said, oh, we'll just do a provisional patent. So you can file a year early. No one will ever look at your patent application at the patent office. I mean, they'll check the formality, but that's it. And then
mm,
it just sits there, and then you get to file the non-provisional, and then you start your 20-year clock there. So it was kind of just a Band-Aid they threw on there. And then a lot of, these companies jumped on it, advertising cheap patent. We can get you a patent filed for a couple $100. We can do all this stuff. That's not what it is. I
mm,
personally do not suggest using provisional applications, except for like if you know, the one benefit of a provisional application is that if you know that you're going to advance your technology within a year, like you're
Mm,
truly going to work on it, like you're really going to do this, we can file as many provisionals as you want before that non-provisional is due a year later.
got it. Mm,
But I can tell you a lot of my clients, I'm like, you're really going to work on this, right? And they're like, yeah, yeah, yeah. And then a year shows up. Hey, you got anything new? And they're like, no. So we end up just spending more money because you got to pay me to do it. We got to pay the original filing fee.
mm,
So I don't suggest it most of the time.
got it.
Yeah.
Make more sense now, and I do understand it a little bit better. So let's talk about your customers. You have held more than 700 patents now by date. What was the weirdest or most unexpected invention you have ever worked on?
Well, I mean, I mean, there's some crazy, I worked for a company called Foxconn for a long time. And one of the really cool patents there was a fabric that could be used as a speaker.
Ooh,
Yeah.
that's amazing. Yeah.
Yeah. Yeah. The only issue is that the way it makes the sound is it creates these super short bursts of heat waves, which turn the atmosphere into the diaphragm. So basically you just create these compression waves by heat. But
Mm.
wearing that as a clothing, you would obviously heat up or burn up. It would turn it
Oh.
so it almost like a small oven. So,
Mm.
using that effect, but it is super cool. There's an issue sometimes when you're dealing with cutting edge. You might get a patent on something that's the value of that patent might not show up for 15 years because it's just
Mm.
it's the building block of that technology. And sometimes you hit it, you've discovered it, but trying to make commercial use out of it might take a while. Obviously that generally works more with high-end research and development in colleges and universities and those things.
Indeed, indeed. Great stuff. And it's very interesting that you shared that example, because I think it would have been treated differently in different places. So, like, for example, is there a, I mean, you have worked internationally, right? So how different it is the, is the patent process in, say, like in UK, Europe, or Asia compared to US? And then what kind of challenges you think founders or usually patent filers face when it is international borders?
Well, you can tell, like, it's the countries. The United States, I actually believe, is very favorable to patents, and it shows in their patent law. We have this rule that's very uncommon in the world, that if you make a public disclosure, you
Hmm.
have up until a year after that to file a patent application.
Hmm.
Europe and China, if you disclose it at all, you've given it away. You cannot. So
Ah.
they don't like patents as much as we do here in the States. And the other thing is that, like, especially the European Union, I actually do this thing now where if I believe that a client is eventually going to want to file in the European Union, I hire a European patent attorney to go over our US application, because the rules in Europe are so archaic. They're very much like, just for example, say that you had a US patent application and you're dealing with the examiner and you're saying, "Hey, my invention does this, this, and this." And they come back and they're like, "We don't like the wording." In the United States, it's a lot easier to change the wording and say, "Hey, you know, this is what it is. You understood what we were talking about. The item was disclosed." I mean, we didn't write an entire book disclosing this because, reasonable people understood what this thing does, the structure, and all the stuff. So we're allowed to rewrite the claims in view of those kind of things. Now, it has to be in the disclosure, but you're easily able to amend the disclosure as long as it was known at the time or disclosed at the time. So you can reword things.
Hmm.
Europe is basically like, if you don't have that exact wording in the specification, generally at the time of filing, with some
Hmm.
small exceptions, you can't add it to the claims.
Okay.
And the claims is what defines your invention. That's what is being examined. And it just makes it very hard because you're throwing this writing to an examiner that won't look at it for 2 to 3 years. And then they are like, "Hey, we have a problem with this wording." And if you can't find a solution in the specification that's exact phrasing, then you have problems. Where in the United States, they're like, oh, we see what you're doing. We understand what it is.
Mm.
And that's the big issue of Europe. I find it very archaic, difficult, and expensive.
Would you recommend inventors in UK or Europe to file it first in US, or does that work? How does that work?
I believe that you technically have to file it in your home country first.
First, okay.
Because here in the United States, we have to file here if it was developed here, and then we get what's called a foreign filing license. Pretty much, I've never had a case that wasn't granted the foreign filing license. But say that you came up with some technology that military would want to use, they shut it down, it becomes top secret, and you can't release it due to foreign laws. But I mean, it's kind of one of those things that you file in Europe. At the end of the day, you want the protection where the money is, right? So if your product is going to be heavily used in the United States, or the largest consumer market in the world by volume, I guess, I don't know. Yes. And they respect patents. China is another one. It's a huge market, but a lot of times you have a harder time enforcing your patentable rights there. So, but China is better than what it used to be in terms of enforcing their patents. I mean, I don't know now with the trade wars and this kind of stuff, but they have gotten a lot better, and they've started to see the value of protecting the research and development that they're now doing.
Got it. Okay. Before we move on to the next question, I want to understand a very high level how much capital is involved during patenting. Would you be able to give us a little bit high level idea of how much in general it costs to patent something in Europe or UK compared to US, and how much it is in US dollars sell both the places?
Yeah, I can give you like the US version. I mean, the US, like China is not very expensive either. I mean, it's on the lower, it's cheaper than the United States. Europe, that one just scares me too. There's a lot of variation in Europe depending on the law firm that you go to, and that's kind of the nice thing about Europe to a certain extent is that, I found that there are centers or, like the people I work with, they're Hungarian and they charge much lower rates than you would in London. And they're just as capable, competent, extremely smart people. And I'll just give you the breakdown in the US. Like if you're originally filing in the US, we typically do a prior art search. And that's basically to go out there to determine whether or not it's out there, previously. Granted, no search is 100%. So I tell people it's kind of like insurance. It covers a lot, doesn't cover everything. But that generally costs the clients between $1,000 to $1,500 out the door. Writing the application is generally between writing and filing and at the USPTO is generally $5,500 to $8,500. So that's putting it all together and then paying the office for the filing fees. Obviously, I've said some that cost less. I've had some that cost more. It just depends on how much time I have to spend on it. The unknown really comes in during the prosecution phase because you're dealing with an examiner. And while there's only one U.S. patent office, there's really like 9,000 because every patent examiner is their own patent office. And you're dealing with different personalities. They see things differently. I mean, it's all about the paradigm in which people come to see these things with. And so you're working there. It depends on the art that they use. So I tell people it's kind of like game theory. It all depends on what they do and what we decide to do. We're going to argue. We're going to do this. So generally, a response, you could be looking anywhere from 1,000 to 3,000, and you might have multiple responses to the office. You're almost guaranteed to have at least one rejection.
Oh, okay.
Yeah, they should call it the rejection office, not the patent office. Their job is to reject you.
Reject at least once, yeah.
At least once. And, I used to work there, and I understand because if you go to your boss and you're like, hey, I couldn't find anything for your first time, they're like, go out and find something. Because you can always search more.
Yeah.
Right. And then if you're like, come back a second or third time, you're like, I really can't find anything. Then they're like, okay, first action issue. But I've always said, if you get a first action issue, we didn't ask for enough in terms of the breadth of the claim,
Mm.
right? So you want a rejection. It also helps make your patent stronger because, we all have our own paradigm. When I write my claims, it's what I'm thinking. Then you have someone else comes in and says, hey, what do you think about it this way? And you're like, oh, you got a point. The word can mean that. Let's clean up this language. And therefore we have a stronger patent moving forward because you can get your patent. You can start building your whole business around it. And then if someone finds some prior art that wasn't discovered, they can invalidate your patent.
Got it. Very interesting. I mean, in my head now, ballpark figure is around 20 grand, just to thinking,
Yeah, I mean, I guess it's like 10 to 20. Yeah, somewhere in that area.
depending, how many rejection and courses you have to go through in and out. I'm hoping that it's similar in UK and Europe also, but
I think it's more expensive. I think even just the filing fees are more expensive. Like, I mean, here in the United States, small entity, which most people are, you're looking at around $700 to file. $730, $750. I think there you're looking at $1,500 at least.
just
But
to file
I
it.
could be wrong. Yeah, that's just the government filing fee. That's not your attorney that you paid to write all this stuff. Yeah.
All this stuff. Got it. Great stuff. Cool. So let's move to the next question. And most of the founders, they're usually bootstrapped. They don't have much money as like capital available for them, right? One of the example comes to my mind is there was a founder who, these Apple iPhones, right? These things when you where is my phone? When behind your phone you have this small kind of wallet where you can put your card. You might have seen it in Apple stores or any other normal
I use it
mobile phone
myself.
store. There you go. So one of the founders, I don't know them personally, but they created a purse which sticks behind your phone, but it stretches.
Okay.
Right? So you can put lipstick in it, you can put makeup in it, you can put a pencil, you can put whatever in it, and it stretches to until a certain volume, and then you can't. But it holds the things in it. So Apple reached out to this founder and said, okay, we would like to buy this patent from you. Happy to pay £1 million. And they rejected it. I haven't seen a product out in last 6 years, and this is around 6 years, more than 6 years before I've seen this with this founder. Now I'm thinking, £1 million would have been good at that point of time. But now I think okay, maybe they rejected it because they thought that the market is bigger, but it wasn't. Who could fight with Apple, $1 trillion company, right? So that tells me that this particular founder has not just lost the money for patenting this invention, but also lost a very big opportunity. But in your opinion, do you know any stories where someone didn't file it on time or did file it but did some mistake and lost everything?
Of course. I mean, it happens all the time. Obviously, I can't get into the specifics of people I've worked with, but I get calls all the time and they're like, oh, well, our product's really starting to take off. And I'm like, well, when did you start selling this product? Oh, about 2 years ago. And I'm like, that ship has sailed. Unfortunately, it's a highly risky endeavor, putting your money into a patent because not all patents work. Not all, hit the market. I don't want to say invention is easy, but making money off your invention, the invention is probably one of the easiest parts. It's the perspiration. It's getting it to market. It's doing all the stuff to create a market for your idea. Because a lot of times you have to convince people that you're solving a problem they didn't even know they had. Right. And that's where the marketing comes in. And, if a company would have come up to me and said, hey, here's your $1 million, I would have taken it, because at the end of the day, I try to say that for some of my clients is that their end goal is what I call mail money. It's money that comes in the mail. It's money that you didn't have to do anything else for. But I understand, like, you believe in your product, you're going to make it, and this is what it is. That's the risk they took. And,
Mm.
I commend them for it. But, that's also, when we talk about the risk of these things, if money on the table or bet on yourself and move forward. Sometimes it works, sometimes it doesn't.
Yeah, even just putting that £1 million in a bank account in 6 years could have like,
Yeah,
given them a
exactly.
very good interest, right?
Yeah.
Great stuff. Um, what's the usual return on investment of a good patent strategy in today's startup ecosystem?
Oh man, that is tough. I mean, again, uh, I always go back to this thing, and it is a South Park episode. I don't know if you've ever seen them, and it was called the Underwear Gnome Economic Theory. And the first thing was like steel underpants. Second thing, question mark, equals profit. And the whole point is this is where everyone is in startup mode. Even if you don't get a patent, it's hard to make money off a startup, right? I mean, so it's figuring out that question mark is what really makes the money. And it's you have to have the confluence of new idea and understanding how to get it to people, and it takes both those skills in order to build something new. And I tell people when they first call, like, look, you don't need a patent to make money. Look around. I mean, the App Store, I don't believe most of those things have patents on them.
Mhm.
Look around your house or your office. you know there's no patents on those things. So let's design patents. I highly suggest design patents. I think a lot of people do not use design patents enough. If you are producing a product that goes onto the market, you should get a design patent on that design.
What's the design patent? I've never thought that you can actually have a design patent and you just open a box of gold nuggets there.
Okay. Well, I mean, let's take your microphone, for example. You cannot get a utility patent, which is what we traditionally think of a patent on that microphone.
Mhm.
But they can come out and say, hey, this is our specific design for our microphone. And
Mm.
one of the ways that helps, it helps protect your molds, especially if you're, making these overseas. They can't make it look just like yours and then import it into your country where you
Mm.
have the design patent. So it's a way, it's like it's a insurance on your product on the way it looks. And it at least allows you to box people out that way. You wouldn't be able to stop people from making a microphone, but you'd stop them from making a microphone that looks just like yours. And design
Mm.
patents are not that expensive to move forward with, especially when it comes, the cost of producing products. So I tell them it's kind of like a small insurance policy. And
Mm.
especially if you're using molds overseas, then you can protect the output of those molds, because those molds can cost you tens, hundreds of thousands of dollars to produce. And the old joke is they work for you for 8 hours and your knockoffs for 16.
Mm.
Yeah.
Yeah, yeah. In our software industry, we have this joke around. When Apple launched, they have this slider button where you slide and open. Like somebody's calling you, slide, and then you say hello. Um, Amazon patented their slide to buy button. So I don't know when it was early days for Amazon when they launched their app, e-commerce app on different mobile devices. When you go to the checkout page, you had this slider button which has all of your information, your credit card detail and everything. You just slide it and then the order is placed. Now it's replaced with a buy now button. And you click buy now button and it does the same thing, right? But nobody else can do it because they have the design patent for that slide to buy
I
button.
don't think it was design patent. I think it was
Was it not? Is it
utility
utility?
patent
Okay.
at the time. That was during the wild wild west of the internet, and
Mm.
des- uh, software patents. And I used to, as an examiner, examine software patents. As an attorney, I used to get software patents for clients.
Mm.
We were able to get them, and basically, I don't believe most of those would be valid today if anyone challenged them.
Ah, so what about this pattern which this dating app has? I've heard that there is an app called Tinder,
Okay.
which you like right swipe and left swipe,
That
and
may
they
be
have.
that may be falling into more of a trademark type of.
Ah,
So
got
like
it.
this is everyone knows us for this swipe right,
Mm,
swipe left, this kind of stuff. Now I don't know it enough, but I would be surprised if they were able to maintain an actual patent on it.
mm,
But there are and that's the whole thing. We are in an it's very hard to get a software patent, but though you'll get a surprise here and there, like someone got granted a software patent. You're like, how, this violates all the rules, and I didn't
mm,
get one based on something that was very similar because they said it was patentable and eligible. The problem is that the rules are not very clear on what
mm.
software can get a patent. Like there's some very clear exceptions. Like if you make the internet run better, you can get a patent on software. If you make your computer run better, you can get a patent on software. If you can make transactions over the internet more secure, you can get a patent on that.
Patent.
But mainly apps where you're taking information from someone, processing it, throwing it through a database, and then spitting out a result, you're not going to get a patent
Get a
on that.
patent.
Yeah.
Great. Would you be able to explain it to our listeners more about like what is the difference between patents or trademark? Um, you know, how does it differ in terms of when it comes to protecting things? You just mentioned trademark word when we were
Yeah.
talking about the Tinder swipe app, right? And how does these two different things help founders to protect their brand better?
Well, that's great. I mean, especially like when you're working with the app space, you definitely want to trademark things. You want to trademark like little modules inside your software, just the name. And it just is all a trademark is a indication of a source of goods or services.
Mm,
But you can use these to protect it's branding. You're trying to distinguish yourself from the crowd. So you use trademarks to do that. I mean, when we were talking about the burger before, you can open up a burger restaurant, but you can't open up a McDonald's.
McDonald's.
And it's there to protect the public. So basically, it's supposed to enable commerce to move faster. I'm driving down the street, I see McDonald's, I know what I'm getting when I go there. Therefore, it's
Mm,
easier to sell me, makes commerce work faster. I don't have to investigate whether or not it's really McDonald's. So
mm,
that's the whole point of trademarks, is to protect the public, but you as a company owner, you want to protect your brand, and and if you're spending tons of money building and marketing, you want to be able to protect that investment, and that's what trademark does.
mm.
Yeah. And here's the thing, you automatically, at least in the United States, I don't know how it works in England and Europe, as soon as you put something on the market with a name or a logo, you have a trademark. What we do is we try to help people register their trademarks with the USPTO because it just affords way more protections than if you're relying on what's called the common law trademark.
Got
Like,
it. Got it.
I think I have a Lavino or something. They don't even have a registered trademark.
Mm,
American Airlines doesn't have a registered trademark. So anytime you see that little TM next to something instead of the R with the circle, it means that they're relying on common law trademarks protection.
got it. Got
Yeah.
it. I think I've heard this also, like old days when you used to like create a song or something, you have to post it to yourself in a cassette or a CD, and then you keep that envelope to yourself because it has a date of postage to you without opening it. And that kind of worked out like, okay, you created it, but
Right.
now like you can upload it on YouTube, right? And then it stamps on it the date and everything, so you have it. Cool. um can we talk a little bit more about so we talked about patents, we talked about trademarks. Can we talk about a little bit about NDAs? Do they fall in the similar kind of space, or they're like way different?
Well, an NDA is a contractual relationship between two entities, right, or multiple entities, but it's between the parties. And
Mm,
yes, NDAs are very important in this space. I always tell people you get NDAs anytime you can. I mean, you just do it. The big thing is that people need to realize that NDA, in order for it to be effective, it has to be a proper contract. And
mhm,
what I mean by that is you need consideration, which is a promise for a promise, basically just the old quid pro quo, something for me, something for you. So a lot of people are like, oh, I signed an NDA with my best friend. And I'm like, well, what did you say you were going to give them in order to keep this secret? Just because
mm,
you wanted to tell them you need to give them something. So, I mean, like, even if it's like $5 or, if it's how serious you want to be, the more money, the less chance you're going to have that NDA challenged as a functioning NDA. So when you're dealing with corporations, in the patent process, a lot of times we go to these design firms or manufacturers while we're still in the middle of the process, because I can tell you, like, we've gone through an entire patent process. Something looked very simple. And then we got to the manufacturer and they're like, yeah, we can't make this. I'm like,
Mm.
what are you talking about? It's so simple. And they're like, just the way injection molding works, this will not work. So a lot of
Mm.
times, you want to have an NDA working with manufacturers and making sure your patentable idea can be manufactured, but that NDA needs to make sure it has some value to the manufacturer when you're working with them on it. Otherwise, it's just a promise, and a promise is not legally enforceable.
Indeed, indeed. Great stuff. So before moving to our lightning round, Austin, I was just thinking to ask you a selfish question.
Oh.
I'm a founder. I have been a founder for many years. What's the best time for a founder to think about patent? I mean, obviously they have to think about trademark and NDAs while they're working, generating money, but patenting looks a little bit harder on its face, very costlier, and then it it required quite a lot of understanding and calculation, in my opinion, to understand, do you want to spend 20 grand or something which might or might not bring value to your brand or your service? So in your opinion, you have worked with several companies and founders, you've been an assessor yourself. What's the right time to think about it, and what are the triggers you think usually initiate this kind of discussion in an organization?
Well, that one's tough. I mean, the easiest one is, if you have an R&D budget, you better have a patent budget on top of that or involved in there, because otherwise you're just wasting money. I mean, you
Mm.
might come up with the best thing. If you're not going to protect it, then why do you spend all this money on research and development?
Mm.
You know, the other thing is kind of like how there are such things as trade secrets, where you can keep something secret and away from the public. And if you can manage to do that, then you don't need a patent and you can exploit it for much
Mm.
longer than the patent. But, if it's something you're going to put out there and you believe it's going to be copied, which it will, if it starts making money, you need that patent there. So it's speculative in nature. You're putting your money and eggs in this basket and you hope it hits. But,
It's like a recipe of Coca-Cola.
exactly. Yeah, that's remained secret forever, right?
Yeah.
So, but don't. But all of these things, you need to talk to an intellectual property attorney about how to do this. You can't
Mm.
just have a trade secret. I mean, there are things that you have to do to make sure that you have a legally binding trade secret, you know, type of thing. And I know that, especially in founders and stuff like this, you probably have employees, and then you really got to work on your employee handbook if you have things that you want to keep secret, and procedures and all this other kind of stuff. Because you can say, hey, I have a trade secret, but if it's all over your company, and even
Yeah.
the guy who's doing the copying or whatever, no one does that anymore. But you know what I'm saying? Like the low man
Yeah.
on the totem pole, he knows all of it, then it's not really a secret.
Secret. Yeah.
So yeah, you got to compartmentalize, you got to do all this stuff. So yeah, I mean, it's tough. It's speculative. You just got to believe in the product. You think it's going to do something. You think it solved the problem
Mm.
that people have, and they're going to spend money on it. Then you really should do the patent. And it is.
Got
It's
it.
at the beginning of the process. It's a front-loaded expense.
Mm. It's like basically opening a company, but like with more protection.
Yeah, exactly. Yeah. So
Great stuff. Well, Austin, I'm enjoying this conversation, but we're limited of time, and we still have one more section to go in our episode. So we've got this lightning round where we have 6 quick fire questions for you, so you
Okay.
can answer them. If you feel one of the questions not you can't answer them, just let me know and I'll skip it. Is that
Okay.
okay with you?
Of
Okay,
course.
great, cool. Now, first question: what are the top 3 strategies in 2025 to protect your service brand startup for founders?
Service brand, it would be trademarks. It'd be
Mm.
applying for intent to use trademarks. One of the things I suggest is, if depending on the timely nature of how soon you want this through, you might come up with three possible trademarks that you're willing to use, file intent to use applications before the trademark office, and then see which ones come back as approved. And then that way you kind of know, hey, we're spending money going down the right path at least.
Got it. Got it.
Yeah.
What book would you recommend to our audience and why?
Oh, that one's tough. I mean, the problem is my clients are all over the place. So we have software guys, obviously we don't work with patents. The other one, it's just, I really don't have one for you. It's
No problem.
startup books, managing money. I mean, the biggest advice I give people, I mean, it wouldn't be book, it wouldn't be this. It'd be like same advice my dad gave me. What you need in life is a good doctor, a good accountant, and a good lawyer.
There you go. Perfect.
Yeah,
That's the best
exactly.
advice. Yeah. What's one attribute or characteristic in your mind of a successful founder?
It's combining the business acumen with the different paradigm and outlook on things that you get from inventors. A lot of times you have the inventor and, their mind just works differently and not necessarily in the most business, related way. And a lot of times what I've seen is inventors team up with somebody, and then that turns out to be a very good partnership.
Like Rolls and Royce. They
Yeah.
both, like, one was like super genius engineer, and then other one like, you name it, how much gold you want. It's in the backyard of mine, right? And look what they became, right?
Yep.
Great stuff. What's your favorite personal productivity tool or habit?
Oh, calendars.
Calendars. Yeah.
I mean, I have calendars. So basically what I've done is I've jerry-rigged, they now sell them, but I was doing this well before. I was getting those pocket computers, and I was taking old televisions. I post them around my house, and they had all my work calendar stuff on it. And that way I was always knew when things would be, due or this or that, because I'm very much visual in my scheduling that way. So, yeah.
Amazing. What's a new or crazy business idea you would love to pursue if you had time and money in the world, like all the money and all the time?
For a while there, I was toying with an idea. I like to cycle, and I was toying with an idea of starting a cycling company for it'd be like your kits, but mainly made for larger individuals such as myself. I'm not one of these skinny, cyclists. I'm, more of the big guy. I know that you have a company in England called Fat Lad in the Back, and that was actually pretty interesting, but something similar to that. And that's kind of was one of my thoughts.
Interesting. I would like to talk to you about that later on after our interview, but good one.
Okay.
And last but not least, what's an interesting or fun fact about you that most people don't know?
Well, I mean, here in the United States, I live in California now, and the big one that people are very surprised to find out is that I grew up in the Gulf Coast of Mississippi, and Mississippi is a very has a reputation of Cajun-like, very Southern, this kind of stuff, and that's it was a great childhood. I would not give it up for anything.
Yeah, it's the movement they're very surprised about, like.
Yeah. Well, I also lost my accent. People are like, "Oh, I would have never guessed," but you live away from a place long enough, so.
Indeed. Yeah, you do. Yeah, my mom kept me with my Indian accent with a lot of pressure because she her grandchildren doesn't have any Indian accent. The daughter-in-laws mostly not, and she wanted to keep someone, so she kept me.
Well,
yeah,
you must be her favorite then. That's the way I would go with it. Yeah, clearly I'm mom's favorite, right? Yeah.
That's what I say. Yeah. Well, Austin, thank you so much for joining me and sharing your story, unpacking the secrets behind patenting and NDAs and trademarks, etc. If people want to get in touch with you, people want to know more, or they have questions, what's the best way to get in touch with you?
It's probably the internet, or give me a call. I'm the only patent attorney named Bonderer out there. So you just put in Bonderer and patents. My website should show up, contact information. It's one of the benefits of having a pretty peculiar last name.
Very good. That,
Yeah.
it helps, right?
Yeah, it does. Well, people could never pronounce it until Roger Federer came out. And
Perfect example.
exactly.
Yeah,
So, yeah.
great stuff. Cool, cool. Austin, thank you so much for joining us today and sharing your inspiring journey and the impactful work you're doing through, helping people with patent journey. It's been an absolute pleasure having you on Founders Podcast.
Ash, it's been great, man. I appreciate it.
Great stuff. If you enjoyed this episode, make sure to subscribe to our podcast and search for Austin Bonderer on Google. You will land on his website. Throw him a lot of questions because I'm sure he will be happy to answer your questions. And we have a lineup of incredible guests and valuable insights coming your way. So don't forget to subscribe. Stay inspired, stay motivated, and keep building.